Hello everyone, and welcome to the first of 3 short videos on the civil court. Once again, these are designed to support AQA's A-level syllabus, particularly Unit 2 and the element that finishes after the tortious liability part. There are 3 videos. The first one we're going to look at is the outline of civil courts and the appeal system. We're then going to look at the procedure to trial and how we get a civil case to trial. And then thirdly, we're going to look at damages and the award of damages. So let's start by saying that in the first instance, the majority of cases are heard in the 218 county courts around England and Wales. The manner in which they're dealt with will depend on the nature and the size of the claim. The largest cases will be heard in the High Court Queen's Bench Division. Okay, so just QBD stands for Queen's Bench Division, where the more serious cases will be heard, the ones that are likely to have the biggest impact in terms of damages awarded. Normally, appeals will go to the Court of Appeal Civil Division. And then finally, for most legal cases, the Supreme Court is the final court of appeal. So therefore, technically, we have a process of courts of first hearing are going to be county courts or high courts. Appeal from the county courts or high courts are going to end up in the Court of Appeal Civil Division. And appeals from the Court of Appeal Civil Division are going to end up in the Supreme Court. I will later on in the video explain a situation in which that may occur, where cases on appeal go from the county court or the high court straight to the Supreme Court. And so, as you are aware, that is called leapfrog. All right, but we'll talk about that later. So, in short, in essence, we can summarise our routes of appeal as thus. The initial hearing is heard in either the county court or the high court. The first appeal will be heard in the Court of Appeal Civil Division, and the final appeal will be heard in the Supreme Court. However, there are occasions on which we might have a leapfrog appeal hearing direct from the initial hearing to the final appeal in the Supreme Court, and I'll discuss those later. Something that we would have discovered and talked about when we looked at criminal courts was this notion of courts of first instance. What is a court of first instance? And a court of first instance is where the case is initially heard, where the trial takes place first. And that will either be in the county court or the high court. And both the county court and the high court have different jurisdictions. They can hear different things. And that will depend on how much, what type of court case it is, the complexity of the court case. The hope is, in most civil cases, that most will be settled out of court. And they hope that they'll be settled out of court by ADR. An ADR is Alternative Dispute Resolution. An ADR are those ways in which we settle court cases not in court. We settle disputes without having to go to court. And there are a number of quite appealing reasons for settling out of court. It's of course cheaper for both the plaintiff and the defendant, but it also saves a huge amount of taxpayers' time, effort and money in the running of the court. There is supposed to be very little difference between either the county court or the high court, but there are some minor differences in terms of the procedure in which we go through and the settlements that can be had. The reality is that cases are heard dependent on which the track they take. Now, I'm not going to explain these now because I'm going to explain them in the next video on procedure to trial. But essentially, the decision as to which of the courts, the county court or the high court, a claim will be heard in part will depend on whether or not it is assigned to the small claim court or the small claim track, the fast track or the multi-track. Now, in all honesty, it doesn't take the brains of an archbishop to realise that small claims are going to be for those minor civil cases, fast track are for those in the middle, and multi-track are for those more serious. In terms of damages, just to give you some idea, Below £5,000 is going to be in the small claims. 5,000 to 15,000 is going to be in fast track, and over 15,000 is going to be in multi-track. But I will explain fully the difference between small claim, fast track and multi-track in a later video. And the reason I'll explain them fully is because they are often asked as questions in the AQA exam. If a case is heard in the High Court, it will be heard in the Queen's Bench Division. I think we've already covered that. So let's have a look at appeals then. I've put this here, both sides are as bad as each other, mainly to say that either side can appeal. Okay, so either side, the prosecution or the defence, can appeal. And these are based on errors. And the appeal is going to be on an error of either law or fact. Okay, now a fact, an appeal on an error of fact is going to be one on which you disagree with the outcome. I am alleged to have done this. I do not agree I have done that, and the evidence doesn't suggest that I have done that. The decision is wrong. That is an appeal on an error of fact. If, however, you think the judge has summed up or interpreted a piece of law incorrectly, then you will be appealing on an error of law. All right, so just get that straight again. An appeal on an error of law is where you think something about the law has been interpreted wrongly. An appeal on an error of fact is where you think the judgment is wrong, where evidence has not been listened to properly, or when evidence has been interpreted wrongly. If the appeal is against the decision of a district judge, so if it's a district judge appeal, then the first appeal will normally be to a circuit judge. And you may recall, if you studied this in Unit 1, in the first AQA exam, you may recall that if you did judges, that there is a hierarchy of judges. So an appeal from a district judge will normally go to the next more senior judge, which is a circuit judge. And these will be normally on procedural matters or on smaller claims in the county court. Otherwise, they go to the appeal court and then a final appeal at the Supreme Court. So if they're on procedural matters, they will be appealed to, often in the same court, but to a more senior judge. And that's normally on procedural stuff or small claims issues. If not, if it's a bigger trial, then we'll go direct to the appeal court and finally to the Supreme Court. We can, as I've said earlier, leapfrog, and that's leapfrog from the court of first instance, often to the Supreme Court. But this is only going to be used when the case is of extreme, I've got green on green there, so it's a case of extreme significance. If the case is of extreme significance, we may see it leapfrogging directly to the Supreme Court. Now, this gentleman with his hand cupped around his ear is meant to demonstrate that an appeal is not a complete rehearing. An appeal is not about listening to every single piece of evidence again, but it considers the documentary evidence, the judge's notes, and witness evidence. Now, the appeal judge rarely changes the trial judge's findings of fact. Rarely. But the appeal judge has, I need to find where I'm going. The appeal judge has three options available to them. The appeal judge can affirm the original judge's actions. And they can do that by saying, we are not going to allow the appeal. We think that the original judge was right. The second option that they have is they can vary the decision. And by varying the decision, they may normally do that through the award of damages. So they may say, we agree with the original judge, but we disagree with the amount that they have awarded. So we may go from, £50,000 awarded down to £30,000 awarded, for instance. And the third thing they can do is they can reverse the decision. And that would mean we disagree with the original judge and we are now allowing the appeal. Claims that involve small sums and appeals to the Supreme Court require a leave of court. All right, so require leave of court if it's a small sum or Supreme Court appeal. And what a leave of court, I should really write that much clearer, a leave of court means is that you have to ask permission of the court to appeal for a small sum or to appeal to go to the Crown Court. And you make the appeal either from the court where the appeal is coming from or where the court or where the appeal is going to be heard, the court is going to. Okay? And that's really that. That's about as straightforward as that. Frequently questions will ask you on the different kinds of courts and the different routes of appeal. That in essence is what they are after. What I do want to just cross over is to look at the burden and standard of proof, because this is different than it is in criminal law. The burden and standard of proof in civil cases equals on the balance of probability. And by that we mean more likely than not. So if we are going to weigh this, if we are going to put it in percentages, that's going to be 51%. Oh, no, it's not. That's going to be wrong, isn't it? So let me change that. Make sure we get that right. That's going to be 51%. That's going to be 49%. Now, in fairness, it's going to be slightly less than that, isn't it? But I'm just working in whole percentages. The moment that the balance tips to make it more likely than not, 51%, then the standard of proof has been demonstrated. Now, you'll remember that's different. If I just quickly put up here, in criminal, we're looking beyond all reasonable doubt. And that, remember, was 99% plus, wasn't it? It's got to be absolutely certain. And the reason why that's the case is that in criminal law, the result of finding somebody guilty in a criminal court case is far more serious. And therefore, we have to make it beyond all reasonable doubt. In a civil case, where we are just looking to put the claimant back to the position they started from, we can use a lower standard of proof, and that standard of proof is going to be the balance of probability. The burden here is on the claimant. So it's the claimant that has to prove on the balance of probability that the defendant had a duty of care, breached that duty of care, and that breach was not too remote and that the defendant caused it. So it's on the claimant. But there are two situations in which the burden of proof shifts to the prosecution. The first of those is criminal duplicity, and the second is res ipsa loquitur. We'll deal with criminal duplicity first. But in short, in each of those cases, the burden shifts to the defendant. Okay, so the burden shifts to the defendant if there is criminal duplicity or if res ipsa loquitur exists. We'll deal with criminal duplicity first. Because of the Civil Evidence Act 1968, if the defendant is convicted of a crime based on the same event as the claimant's claim in negligence, the claimant's claim in negligence will be immediately satisfied. And the reason for that is if there is a criminal case, then the court has been satisfied beyond all reasonable doubt. And as we looked at above and we saw above, that's going to be 99%. They're going to be 99% sure. Now, if then there is a subsequent civil claim, we only have to demonstrate to the court 51%. Well, we've already proved that the defendant is 99% liable, so we don't have to now go back to prove that they are only 51% liable. The example I'll give is a crash car injuries claim. Let's say the defendant has caused a crash by driving dangerously. They have already been convicted of dangerous driving to the standard of 99% beyond all reasonable doubt. If that's the case, then the claimant doesn't need to prove that the defendant caused the damage to their car at a standard of 51% on the balance of probabilities, because a criminal court has already proved it to a much higher standard. In this case, the defendant will have to prove that he was not negligent. And that's going to be very difficult because a criminal court has already said that they are liable for the offence of dangerous driving. So it's going to be very difficult for the defendant to demonstrate that. So where the defendant has been convicted of the same circumstances in a criminal court, there is no need for the claimant to have to prove that the defendant caused the damage. The only issue for a court in this instance is the amount of damages. So the court will only be concerned now with how much damages to award. The second element is something called res ipsa loquitur. And what that means is the thing speaks for itself. The accident causing the damage would not have happened unless someone had been negligent and the thing causing the accident was wholly under control of the defendant. So, I guess you could say res ipsa is something like it's bloody obvious. If I'm allowed to slightly curse. If something's bloody obvious that the only way that it could have happened was by the actions of the defendant, then the claimant doesn't have to prove it. But as usual, you know we love our three-part tests in law, don't we? And the three-part test for res ipsa, often referred to as just res ipsa, just res ipsa with the A. The first test is that the thing caused the harm was wholly under control of the defendant. The thing that caused the harm was wholly under the control of the defendant. The second thing was that the accident that caused the damages complained of would not have happened unless someone had been negligent. And the third thing is that there is no other explanation of the injury caused to the complainant. So there's no other explanation. And the case that we use to demonstrate this, the famous res ipsa case, is Scott versus London and St Catherine's Docks. And in Scott versus London and St Catherine's Docks, the claimant was injured by a sack of sugar which fell from a crane operated by the defendants. So let's have a look. Sack of sugar falls from crane. The claimant did not have to prove that the dock company were negligent, as they were assisted by res ipsa. The thing that caused the harm was the thing that causes the harm is the sack of sugar, was under the control of the dock company. Sacks of sugar do not fall from cranes unless someone has been negligent. And there was no other explanation for the injury to the complainant. A big sack of sugar fell on their head. So, the only people that had control of the crane were the dock. The sugar could not have fallen from the crane unless somebody had been negligent. And there was no other way that the claimant could have got injured. So that way, why should the claimant have to prove that the dock was negligent? What should happen, and what did happen, is they use res ipsa, which means that the defendant has to prove that they were not negligent. Since the three stages are fulfilled, the claimant doesn't have to prove his case. The burden of proof moves to the defendant, who has the opportunity to prove that they were not negligent. And they do that by demonstrating there was some other explanation for the accident. So therefore, in all fairness, that's going to be difficult for the docs to prove. There's no need for the claimant to demonstrate that. Now, this is most useful, it has to be said, in cases where it's difficult for the claimant to demonstrate the negligence of the defendant. Take Mahan and Osborne. All right, Mahan versus Osborne, 1938. The claimant went into hospital for an abdominal operation, an operation on their stomach. After the operation, the claimant remained in pain. And to be honest, they died when they should have made a full recovery. Not very nice at all. In fact, what had happened is a swab had been left inside his body. Now, I've got a pair of forceps here, but the idea is in Mahan versus Osborne, it's a swab that's left inside his body, which caused an infection. But there are cases where other medical instruments are left inside patients' bodies. The court stated that res ipsa applied as a swab is not left inside a body unless someone has been negligent. The swab is wholly under the control of the hospital, and there is no other explanation for the death of the claimant. This is helpful to the claimant because they were unconscious at the time of the accident. Therefore, they can't give evidence. So res ipsa helps the claimant where they don't have any evidence to be able to offer. So in both of these cases, the claimant won. But let's just compare that quickly with Pearson versus Northwestern Gas Board. A gas main outside the complainant's house explodes, killing her husband and destroying the house. In this instant, the gas board was able to show that they had not been negligent, that they had taken all reasonable precautions to deal with the gas leak. There had been particularly cold weather in this instance, and this had caused the ground to freeze and then buckle during the thaw. And it's this that had caused the pipe to fracture. Having regular inspections and a 24-hour emergency call-out team was a sufficient standard of care, so the board was not negligent. There were other reasons for the gas pipe to be fractured, and those other reasons were the extreme cold weather. The board were able to show, so when the board had to prove that it was them that were not negligent, they were able to show quite clearly because of the precautions that they'd taken. So in this instance, the claimants lost. So you can see quickly how res ipsa works to help the claimant where there can be no other explanation, where the control of the incident is wholly in the control of the defendant, and that somebody has been clearly negligent. Okay, so the next video we will look at is the process to court. How do we get somebody from, in the first instance, a dispute to, in the final instance, into court?